you are buying, because the interest, as I've cited, some of them are perpetual, permanent. So definitely the amount you pay for it will be lesser than, say, a leasehold interest that for, let's say, 10 years. So all the time you should know what you are buying. You are buying an interest in land. And so you must be careful about it. That is why the law has gone through the trouble of setting out the interest you can have in land. And maybe with time we may have to inquire what type of interest we have purchased in the land we have auditorium on, so that if it's the one that is immediately terminable, then we may have to take immediate steps to make that arrangement. Okay, so as I've said, we have the allodial title. This is the ultimate title you can have in land, and usually vested in the stews. And this one, we will talk about how originally lands were acquired. People fought through conquest. Then they take over and settle. You go and fight. If you win, then you settle on the land, that you acquire, and then you will be able to manage it. And then you see that people also purchased, buying land. Some also go for hunting, and they discover an area that is uninhabited, and then they settle on that land, and it becomes their property. And then you see that in our tribal histories, we have people moving from areas, settling, and all that. Through that process, you acquire land. So originally, this is, conquest and discoveries were the original, modes of acquiring this huge title, the allodial title. But you could get it through settlement, gift, purchase, by agreement. Some can exchange it for something else and all that. Some are even gifted. You go to a community and you serve them so well, they can, give you land to settle on. So another one is the customary law freehold. I wouldn't want to bother you with technicalities, but there's also an absolute interest that flows from the allodial. This one is not the highest, but it's the second highest. There are two others that will come to. But for them, they are also, they don't have limited tenure. They run for life. They have perpetual duration, okay? But the point is that there can be a time when those people holding this interest may die, or for some reason they may abandon it. There may not be any successor. Then it reverts to the allodial title holder. That is why it's classified that way. So next, and the common law freehold. This is usually where you go to a community and then you want a land, they go and give you a portion, you pay for it, and that kind of. It's done under the common law regime. Okay, so but to note that it's also a type of interest that you can have in land for which you can buy or somebody can transfer to you. Okay, next. Is refractory interest. So this one is where you are a member of a family or a stool. You are a subject of a stool, a community that owns the allodial title. And as a subject of the stool, you are entitled to go and occupy a portion that is uninhabited or not possessed by anybody. But this one definitely tells you that it's something that had happened years ago. This time, we say there's no ownerless land in Ghana. Every land has an owner now. So now you may not be lucky to have this. But you see that it's still relevant because you have to prove your root of title. When you are buying land, you see the model that you can use. You can go the formal way. If you want to go the formal way and you do your search will show that the land was originally acquired by so and so family or stool, and it has passed through this hand and all that. So definitely it may show you the source, and that is important so that you know whether it is a permanent interest you are buying or a limited interest that you are buying. So this is refractory interest, the common law freehold, the customary law freehold, they all form part of the second highest interest you can have in land, which is subject only to the allodial title. Yes, next. So the leasehold interest. This interest is very important. This has a specified duration, or we say that the duration should be capable of ascertainment. Sometimes, just you can cast your mind to the way we rent apartments. But here we are talking about bare land that is given for more longer periods, like 10 years, 20 years. But so when you take your own apartment as an example, then you can give it to somebody for 10 years, 5 years. Sometimes you may indicate the starting point and leave it. Sometimes you can even, attach it to a contingent, the happening of something, so that they can move out. But in all cases, it must be for a certain duration, or that duration it should be possible that we should be able to calculate or come to the end of that tenure. So the important thing is that it should have a starting date and an end date. Okay, and this is what is so important, because since 1969, you will find that the first four, the allodial interest, the customary law freehold, the common law freehold, and refractory interest, the law has banned that for stew lands, you cannot acquire such interest in stew lands. So if somebody tells you that, so this means that first and foremost, you should even determine the kind of land that you are buying. So that if it's a stew land, and the person tells you that, I'm selling you for affable, let's say that way, affable, you own it forever. And for that reason, he's taking big money. Then you know that that will not be valid. That will not be valid. So you are throwing money away. Then you know that since 1969, there has been a cutoff, and you cannot have this interest. But remember that it's only in respect of stew lands. But per this law, they have added family land to it. So that means that it's now left only for individual lands. Individuals who had acquired the higher interest, be it the customary law freehold, refractory interest, or the common law interest, they can sell to you still, and you can get the permanent interest. Okay. So next. So we have the customary tenancies. These are the Abunu and Abusa systems. These are granted to farmers or tenant farmers who move from other areas just to go and do, say, cocoa, or cultivate some crops, cash crops in particular. And then there can be an arrangement between the owner and the tenant farmer that when you finish, we give you a portion, or we share the produce that come out. First, it was, you just start by having, say, we are doing Abunu, and that one is just given, that piece of land is given to the tenant farmer, and then he will use his resources, everything, and cultivate. So whatever comes out, you share 50-50. And then the Abusa too, there is a contribution from the land owner, and then it is shared 1/3. But these two systems have also been collapsed by law, saying that it is not, you cannot predetermine. It's all about agreement, because the owner may not provide any resource, but can say that still I will have to test. So if you agree, that is what will go. So, but the examples are what I have given. Next. Okay, so rights. You see, we have talked about interest. Anytime you are reading the Constitution or any land enactment, it will differentiate between interest and rights. We've defined the interest to be bundle, a set of the rights that you can have in land. And those ones have been identified as the allodial title, the customary freehold, and the rest of them. But here you can still have some individual rights that you can exercise, particularly on the land of others. And that is what makes it interesting. You have your land, I have mine. But the law allows me to exercise some rights on your land. Not particularly coming to use it, but to even direct you sometimes as to how you can use it. And that is in respect of easement. Let's say you have 3 plots of land, and then you sell one to me, and then the only way I can access that property is to go through one of your plots, the existing plots. Then the law will force or give me that right of easement to pass on your land to access mine, because I have a right to enjoy the property you have sold to me. Okay, then we have profits. Profits, these are ancient rights that you can go to the land of another and pick something on the soil, or something that grows out of the soil. So mushroom and snails and all that, they arise from this right. You don't go and arrest the person and say, I've caught a thief, because that's a right. But, our time, we hardly find that. And restrictive covenants. Those who have bought properties in estates, you find that they even restrict you as the number of stories you can build. And even they will have to even approve your plan and all that. Sometimes they've sold it to you outright. Let's say the lease they have, they are on expired term, they've sold to you, which we call the assignment. They've sold everything to you. But as part of the agreement, they put there that you can't grow, let's say, trees, or you can't rear animals and those things. Those are the restrictive covenants. Covenants are just by agreement, so restricting you as to the use of the land. Next. Okay, so next. So this is the explanation I've given over there, the prophet. Yes, next. Next. Okay, so one interesting thing. You see, earlier I said that for the freehold interest by law in stew land and family land, you cannot acquire. But you go further, and it tells you that, so a citizen, there's a differentiation between a Ghanaian citizen and a foreigner, and the rights that respectively we have to acquire landed property. And it says that, so this is section 9.2 of the Act 1036, that a citizen is precluded from acquiring a freehold interest in stew or family land with the exception of usufructuary interest. As we said, the usufructuary interest is where you are a member of a family and the family has a allodial interest in land. Then as a member of the family, you are entitled to go and occupy a portion that is not occupied by anyone. Okay, if you are a subject of a stew too and the stew owns the allodial title, then you have that natural, what we call inherent right to enter onto an unpossessed portion and also settle. Okay, so we are saying that for citizens, you cannot even acquire, but the usufructuary interest is accepted because the nature and the way it is created is different from the other two. And then here, for foreigners, there's a more grave limitation. They cannot acquire the freehold interest just as, in any land. So the Constitution is clear. So it means that the first one, a citizen can acquire, let's say, a freehold interest in a private land, individual land, not stew or family. But when it comes to a foreigner, he cannot get any freehold interest at all, not even from a private person. So some of us in our businesses, we deal with foreigners. They buy land for, industries and other economic enterprises. We must guide them as to what they can do, especially when they come with the foreign company as external company. They tell them what they can get. And so that is it for a foreigner. And then the only thing they can do is the leasehold. Of course, that is what is applicable to even citizens when it comes to stew and family lands. But we can have more. The foreigner can only get up to 50 years. 50 years. And then the 50 years at any one time. So at once, you can't give them, say, 51. That will be void. It will be like there hasn't been any vesting or any transfer at all. Okay, but when for a Ghanaian, you can even get the lands that we acquire from stews and families. That one you have an undetermined 99 years to go. And because there's a continuous payment of ground rent, it's assumed that you owe it forever. You own the interest forever, but it is not. And these limitations are to ensure that land will not be appropriated by few families for themselves alone and leave the rest. Because as has been said, land belongs to those who are presently living, those dead, and those who are yet to come. So that's why from the preamble we saw that one of the objectives of the law is to ensure sustainable use or management of land. So all these things have been done just to, achieve that purpose. Next. Okay, so we come to property rights of spouses. I don't know if I could end here for questions or we continue, maybe with the direction of Apostle. Thank you. So, yes, we are here, we are men, we are establishing homes. So, family is an integral part. So, the law also is concerned about how we deal with property as spouses. Okay, so we say that the Constitution, per Article 22, recognizes and sets general guidelines for spousal right to property in Ghana. The Constitution further mandates Parliament to pass law to fully regulate spousal rights to property. The issue is that there are two instances under which property sharing can take place. You can have a case of one spouse dying. When one spouse dies, then if the deceased left a will, then the will will be used to determine or distribute the property that will be left behind. If there's no will, then our intestate succession law, PNDC law 111, that one sets out how the properties that have been left behind should be shared. maybe on another platform, we may want to go through that because that's also interesting. If there's only one house, then that house goes to the surviving spouse and children. If there are more, they select the best. You have serious cases coming out of that. And all household chattels, including cars that are not used for commercials, they all go to the surviving spouse and children. So these are basic things before the remainder is even shared with portions going to the surviving spouse and children. But this was a law that was made by the PNDC, looking at how women were suffering, when there's a demise of the man in particular. Thank you. And so here, we're saying that the Constitution has set out a parameter or the parameters for managing the properties of spouses. So for death, we are certain, and the Constitution is clear that when a spouse dies, the surviving spouse and children should have access to the property. And so to the extent that even where you make a will and you don't provide for your spouse and children under 18 years, they can still go to court and ask the court to apportion a sufficient part to them. So when you are making a will, you have the freedom to dispose of your property, self-acquired property, but you can't do it to the detriment of your surviving family. Okay, so here, Parliament was to enact a law that will give further details on how to regulate, because the Constitution says that when there's divorce, that is where the controversy comes. Because it appears that the death case has been settled, but where there's divorce, no wonder the church and the biblical principles do not even encourage that, because when there's divorce, you have so much tension, and the law is saying that there must be equitable distribution of the property that have been acquired during the marriage. And remember, it's properties acquired during the marriage, so that properties that are brought into the marriage will be owned by the party or the spouse that brought it. Properties that are gifted, they are not acquired jointly. So that will also be owned by the party that received it and all that. But properties that are jointly acquired, first, you needed to show, well, let me say this. Women, the beginning of civilization, were considered as chattels, as part of the properties of the man. So actually, when you get married, okay, you are to help the man with your children to acquire property. All the right you had was the right for maintenance and care to be provided for. Okay, so women were not getting property, but with development and changing times, they realized that no, a woman also has a right, and so should be accorded like that. But the law required the woman to show contribution, that I contributed to the acquisition of this property. And that will mean financial contribution. And then there were so many difficulties. For example, who will help the husband to build or buy cement or will keep the receipts? So even the proof of that was a difficulty. Then, thank God, our Supreme Court realized that the contribution, the domestic services of the woman, it cannot be quantified. In fact, they are even more than the one that a man does. And it is that which gives you the confidence and peace of mind to go out and look for money. And so whatever you acquire should be shared. It is the sharing ratio that became a difficulty. And when the court started, remember, the Constitution mandated Parliament to enact the law, but Parliament has failed. And when there's a matter before court and there's no enactment or specified law, they cannot say we don't have any law, so go home. They will have to use fair principles, the equity that we talked about, to settle. And so when they were having cases, remember the case of Odate and the rest of them, the court said, if none of the parties is able to show distinctively that he or she acquired the property only for himself or herself, then we'll share it 50-50. Because once you can determine that this person brought 40 and this person brought 60%, we will share it 50-50. But that is the general rule, so that where there's evidence that one party did not actually provide the services or did not contribute that much, then they will shift the percentages. So you see that is why the court has not been friendly to Odate's former wife, but she keeps going because of that 50-50 thing. But it's not automatic. It's not automatic. Yes, next. So because Parliament has failed to provide a specific enactment to regulate the property rights of spouses, they try to deal with that aspect in when it comes to land acquisition in this one. But there should have been one that would deal generally with spousal property, because spousal property goes beyond just land and landed property. Okay, so section 38 of the Act says that spouses who acquire landed property for valuable consideration shall be treated as parties to conveyance, that's transfer documents. It also states that a conveyance to one spouse will be treated as trust for the spouses unless the conveyance states otherwise. So now, the law, what has happened previously is gone. The law always looks forward. It looks prospective. So now, if you buy property, you are married, and you buy property, and then it's not clear on the document that you bought it for yourself, then when you are going to register it, they will register it in the joint names of yourself and your wife. If it's the wife, the same treatment will be given. But there has been some difficulties here because, the blows will start, in the homes, and it may not be well, because this determination will be done by not a judge, but the registrar, who may not have the benefit of how to deal with disputes of this nature. So 38 says that if you buy a land and then you want to register it, once you bought it at the time you were married, then it will be registered in your joint names. And that also means that if somebody is selling land to you and the person is married, then you have to ensure, there's a subsequent provision that says that one party cannot unilaterally sell property, spousal property. So you need the written agreement or consent of the other spouse before you can buy. So if you are buying from somebody who is married, then you need to make that inquiry so that you are sure that that is given. If not, you don't get anything. The law is that nemo dat code nan habet. You cannot give what you don't have. So you cannot get anything from a person who doesn't have. So if you sell it to me and the law says that I don't own it alone, then you get nothing. And sometimes you might have gotten a good deal. After so many years, it's challenged, and then you lose everything. So next. Okay. So that section 47 says that one spouse is prohibited. That's the point I've made. So next. Okay. So I've done a paper. I did a paper with another law student. We looked at the implications of these two provisions that we have seen, Section 38 and Section 47 of the Land Act, which has dealt with spousal property in land. And these were some of the conclusions that we came to. That one, the landed property acquired by a person before marriage remains the independent property of that person of that spouse, after the marriage. So within the marriage, that will be an independent property. Two, so it means that if there's going to be a divorce, then that property will not be counted among the joint properties of the marriage, which can be distributed. Two, a landed property received by a spouse as gift during the subsistence of the marriage shall be independent property of that spouse. Gift is not a joint acquisition. Nobody expended, resources or time to get that. It was just given. So for that spouse, you can't say that because we were married, your father gave you Trasaku house, so it's for the two of us. No. That will not happen. Then the third one is a spouse who acquires landed property for himself or herself for valuable consideration prior to the coming into force of the law. That is the New Land Act. That person will continue to hold it as immovable property. Before some recent cases, the courts got confused. They came to the conclusion that every property that is purchased or bought or acquired during the subsistence of marriage is joint. They came to that firm conclusion because of what I said, that the woman who may not provide fiscal contribution also provide domestic services, which are substantial. So the court came to that general rule. But later they realized that you can have a marriage where the parties will have some form of agreement, whether by conduct or by practice or by written agreement, that we will acquire our independent properties. And that the court will accept, because there has been a case, Finn and Finn, where the woman bought her own property at a point in time, she sold it and kept the money. Then later on, the man also sold the property that he bought during the marriage. And then they connived, the two of them came together and wanted to get the property back. So they said that, there was no consent with the woman. So the woman sued the husband and the person who bought the property just to get the property back. And the court came to the determination that because they were able to adduce evidence that previously the woman sold her property without giving anything to the man, and that was agreed. So such a marriage, it means that even though they are married, it's not every property that they acquire that will be joint. But that is an exception which only one case has brought. But the general rule is that once the marriage is subsisting, any property that we acquire is likely to be taken as joint, and upon dissolution of that marriage, then they will share. Okay, so next. Okay, so if a spouse attempts to acquire landed property for himself or herself during the marriage but fails to indicate that intention in the transfer document, that's the conveyance, then both parties will be deemed to own the property jointly. Okay, we are just making deductions from the general rules that we saw in section 38 and 47 of the new act. A spouse cannot unilaterally sell, exchange, mortgage, lease, joint landed property, or enter into a contract to dispose of or encumber the same without a written agreement executed by both parties. This is what I spoke to earlier, that now if you have a joint property, you cannot sell it alone. There must be written agreement signed by you and your spouse before you can do valid transfer. So that if you are acquiring from somebody who is married, then you have a duty to do that. Okay? So, and when it comes to land and other purchases, we say caveat emptor. You, the purchaser, you have a duty to make all the inquiries to make sure you are getting value. So if you fail to do that, then you will take the loss or liability that may come along with it. And so you can look at the link to the article and read more about it. Next. So offenses. The law has seen the menace of land guards. Land guards have been tackled in so many enactments, but because it deals directly with land, they brought it here also. And so here, if you don't have any interest in property, but you go and stop or supervise a piece of land, you don't want anybody to come there, that is an offense. And if you look at the term of imprisonment, between 5 and 15 years, and there's no opportunity to go for fine, to go in, because we just want to fight land guard activities, with all the force that we can marshal. And then two, if you personally or through another person uses force or intimidation to prevent a lawful owner from developing his or her land, you commit a criminal offense, and the penalty shall range between 10 and 15 years. You see that the first one, the minimum sentence is 5. But the second one, the minimum sentence is 10. So it means that is a more aggravated level. You are using violence, intimidation, to stop somebody who has, title to the land. And you are preventing the person from developing. So people who don't have any interest in the land, they can stop you just to extort some money from you. You find it in maybe a developing community, some of the urban communities. When they see that people are just moving in to buy land, then they try to come in and extort money. So the law has provided these very grievous offenses and penal regimes to stop that. Okay, so next. So another offense is that if you have no title in land, but you purport to sell or make a grant to another person, or you make conflicting grants in respect of the same piece of land, you commit criminal offense. So here is about those who sell land. The person might not have it, so a pure case of fraud. I own this land when he has no document proving title, and then sells it to some other person. When you report it, it's a criminal case, and the person can suffer the range of punishment. If it's a fine, then between 90,000 and 180,000, and the imprisonment terms between 7 years and 15 years. You also have the case of the chiefs, some of our chiefs, who can sell land to multiple people, the same land. And I have suffered one before. I bought land, and then after a long while, attention came that we should develop it because people were coming to that area. And the chief had given our place to another person. So we had built to lintel level when this person came, the third person, came that, he has bought the place, so we should remove our blocks. So we were laughing. And then when we went to the chief said, oh, when the person came, he was having big money and said he wanted back and front. So he sold it to the lady with the intention that when we come to complain, he will give us another piece. And definitely what they will give you will not be a good one. Why wouldn't they give it to the first person? So definitely when they do that, then we should also see, yes, back and front. So when we see that, it's a clear case of criminality that we should avoid. And that is where the problem is. The chiefs, they know. They've given the place out. And that's why now they are going to establish customary land secretariat where they have to record every transaction, the existing one and new ones, so that you could even go there and make searches. Because most of our lands are not registered. So when you even go to lands to do the search, you might not find anything there. But, so we hope that when that is done, there's no time, there's no deadline for them to do that. So we may have a long time to achieve that. Okay, next. Okay, so this is the end of the short presentation. The slides will be available for further reading. So with your direction, I want to open the rest. Thank you.
Thank you. So please, if you have any questions, you can just raise your hand.
Men. 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 They like dream now. Yeah. Thank you for the teaching. I have two questions. One, you bought 2 acres of land and you work in this mining area. So you took out the gold soil because it's a living thing, it's good. And you put it like you bought the land in Accra and you took the gold from the other gold land and you brought it here. In your talk, you said when the mineral is in the soil, it belongs to the government. But this one, it was not in the soil. I brought it there. So, how are you going to handle this one? Soil. Okay, who they are?
Beneath, our land keeps traveling. That's why I travel from Obuasi to Dunkwao. And then it's going, it's a myth. And so you can't, it should come to your house. So in actual fact, gold is not a living thing that you plant and then you say that. So you pick the soil from anybody, then you take it and put it so that to grow in places here.
Okay, thank you. And my next one is 2 young people, I'll say they were dating and they bought a land. When they were not married. And later they got married. So with this, how are you going to, like if someone wants to buy it or if something happened, how are they going to share it? Because when they bought it, they were individual, not joint. Thank you.
very much for this question. Yes, this one you have, there have been a number of cases on that. Some people in our traditional setting, they stay for a long time before they do the real marriage. I mean, the formal marriage. So you will have a case where they acquire properties together, okay, or one. Thank you. Hello. So you find that maybe one bought the land, built and completed before the marriage. That one would have come in one of the exceptions we had. That one will be the independent property of the one who acquired it. But sometimes you have the land maybe bought before the marriage, but developed during the marriage. Then the court will look at the significant contribution. Is it that, something small was done on the property or just full development? If full development, then it will be available for distribution. But of course, the court will take account of what was acquired alone. So this is where the 50-50 might not come in, because the court will take note of the exclusive acquisition. Okay, so my own cousin came to me that, he's divorcing the wife, and the wife's own interest, the only interest is to chase the property that he acquired before the marriage. And I said, give me documents that you acquired it alone. He has a right. He has a right because, according to him, he built some few blocks, and then they actually built the rest during the marriage. But because he got it, land before that, there's a principle in law that whatever is attached to land becomes part of the land. But that is in respect of family land, or you go and build on somebody's land. But when it comes to marriage, the law is to do justice. So where the parties have toiled to develop the land, that will be joint. It won't say that I had my land, you added to it, so it has become part of that land and I will own it exclusively. No. The court will say that this one is susceptible to sharing, but the court will take account of the part that was exclusively acquired.
Please, I have two. I don't know whether it's a question or one might be a clarification. So the first one, I would like you to tell us, as individuals or private persons, when you make up your mind that you want to buy a land or you've already bought a land, how soon are we supposed to develop on the land? Yes. And the second one, when you were talking about allodial title, you made mention of the compulsory acquisition by the state. I want you to tell us, how does a property that belongs to me, the state will tell me that they are coming to acquire that land, and what are they supposed to do if they are acquiring that particular land? What are they supposed to do for me, the person they are acquiring that land from?
Okay, good. Thank you very much. Very interesting questions. Yes, so the first one, you have land, you bought land. How fast must you develop the land? In law, we say that possession is 9/10 of the law. Means that if you are fighting over land with someone and you are already on the land, you have a fair chance of winning. Subject to other laws, other rules that may be applied against you. But the point is that you need the land, you have to register and go through the process. But in our system, that cannot be done, fast. So the best convenient way is to start building. Because when you're on the land and somebody comes and you don't even have title, if that person goes to court, it is that person who have the burden to establish his title to the land first. So if he fails, then you are on the land. You have not been declared the owner, but you are on the land. Okay? So I would advise that you start doing something. And that goes to how you acquire property. We couldn't go through that. I alluded to the fact that you could go through the formal way, where you are interested in a piece of land, you go into a contract, and let's say you can pay some deposit just to hold the hand of the person so that you could go ahead and do detailed search through lands, and even when you go and the lands documents show that he's the owner, you don't even rest there. You have to go to the land and talk to the people there. Because you may have a different person, and then the name is there, but somebody else land. In case where, for example, the person even
Praise the Lord. Madeline, would you want to throw a bit of light on the compulsory acquisition one? I can feel that you have a bit of background to the subject. I want you and I to discuss it.
But with compulsory acquisition, there's something in law that they say that exclusivity is not absolute, like you were saying. So the fact that you own the land doesn't mean that it absolutely belongs to you. So, for example, we own the stretch, right? There are people also who are owning other parts of the stretch. So if the urban roads or whoever, they decide to lay a road network, right? You can't say because I own maybe from our wall to the next wall, if there's a wall coming through here, we will block it. Because it serves the general good of the community. So in that instance, they will compensate you for your piece of land that they are taking away. Especially when it comes to road networks and other public things that benefits the whole community. So they assess it. Sometimes they resettle a whole community in itself to another location just to pave way for some of these things. So before they do that, they will definitely get valuation people, valuers and all that to assess the value, the interest that is left in the land and all that, and then they settle you. So that's how compulsory acquisition works. By whatever you do, the state has the powers to do as they please, so they have exclusivity.
Sorry for that interjection. Yeah, so the question on how fast do you develop the land? Okay, I was still on that one. Okay, so on compulsory acquisition, you were asking how the government could acquire your property when you are not ready to sell. You know, always we talk about the individual good against the common good. Every government has what we call the power of eminent domain, the power to acquire private property for a public purpose. So that's by law. The law already guarantees your right to acquire property. But it also says that the state can acquire your property by its own condition, that the state will do so by law. So we had the State Lands Act, which permitted lands to be acquired, and that has been repealed and consolidated here. And so there's a process. It should be by law, and the law has clearly set out what must be done. And then you see that in the past we have had the case of non-payment of compensation. The law requires that there must be prompt, fair, and adequate payment of compensation. So it means that the money should be ready even before the state takes it. Okay, but you don't find that. So here, the law has provided for an escrow account where monies, MDAs that are interested in acquiring a private land will have to even put the money into that account before the state will go ahead and issue an executive instrument to acquire it. Remember the case of the Achimota Forest and then the Ramsar area where they always talk about the EI that was revoked by the president. Okay, so the state can always acquire a private property, but for a public purpose. And that is where the Constitution under Article 20 provides that if the state acquires the property for a particular purpose, but fails to use the property for that purpose, then the original owner or the immediate owner at the time of the acquisition will have the first right to buy the property back. Okay, and that is what is used by the previous regimes, where the families will go back and say, we're not paid compensation, so release part of the land to us. Okay, so it has to be treated that way. And so let me just recount what is in Article 20, and then we'll have a fair view of how that right is exercised. Okay, so Article 20 says that no property of any description or interest in or right over any property. You see the interest or right, we are meeting it here. That's why I explained it earlier. Shall be compulsory taking possession of or acquired by the state unless the following conditions are satisfied. So because it's an invasion of your private rights, it must be done in the defense, in the interest of defense, public safety, public order, public morality, and those things. Okay, or to do something for the general good. So when that fails, then the state can if the state refuses to use the land for that specified purpose, then you will get the first right to buy the property. Okay, so the state can acquire it. But before I left, I wanted to throw a little light on how you acquire property. And I said that there's a formal way you acquire it where you secure the contract first. You are interested in the land, the person is also interested in getting your money. So you reach a balanced situation where you say, I can pay half and then get an agreement with you that you are going to sell it to me and I'm going to buy at a particular price. So that will tie our two hands so that you can do detailed search or due diligence, because you have said that if you are not diligent enough and you buy property, later you can lose your money. Or if there is a future litigation, then it means that you're going to get a devalued amount if you are even lucky to recover the money. So that is what we should take care of. So when you secure it to a contract and you do all that, I've said that you don't even rest there with the formal search through the Lands Commission. You must go to the plot, the land, and even talk to the people there. Talk to the people there. I was interested in a particular land when I went to the land and did some movement around. I had a chat with the pastor there who said that, oh, I have cried on my baby, but yes, I see. So clearly, the signal is given that you are dealing with a very so. But if you are just going to the formal search at the Lands Commission, you might have found the name of the stool or something there. So for land to be sold, you have to identify the person who has the right to convey. Every land and the one that can have the right to transfer the property to you. So if you don't get the right person, that means that you are throwing your money away. If it's a stool land, remember it has to be the occupant of the stool with his, we say consent and concurrence of the principal elders, not the chief alone, because in law that can be voided. So to be sure, then you see that normally if you look at your indenture, you find that the other elders have signed, not only the chief. That is the reason. Okay, if it's a family land, then the family head, but not he alone. He must do so with the principal members. You see that every family, they will have some standing members who family members who can be counted. So they should also approve of it before. So some should actually sign to indicate that they have given that consent. And of course, if it's an individual, then you have to establish the identity of the person, and in your search also identify and establish that he is the same person. Because you have some precarious situation with the gangs where they have a patrilineal system. So you can have the whole children numbering about 10, and each is selling to different people. It becomes messy. That is why your search has to be deep. If not, in some cases, a lot of money will go away. So the informal one is just you see and just go ahead and negotiate and pay the price. But that one, you run huge risk. And you see that sometimes you are forced to go that way because if you are not buying, somebody is buying. But at least you should take calculated risk and know that, yes, I'm taking a risk that for this place, I may lose it or get it. But you shouldn't go in without that certainty.
I have two questions. The first one, if I followed the representation, lands in Eastern region. So we are buying some lands in Eastern region. And we are buying some lands in the Eastern region, and we are asking for a freehold. When we went on the land, these are farmlands with cocoa, and what they tell us is that it belongs to different people. So it was going to, the chief would be the one representing them. I just want to get clarity that with such a land, can we get a freehold? That's my first question. And then the land doesn't have any site plan or anything. So our surveyor is the one going to do it first. In that case, that's my second question. How do we go and do a search to know? Because if with my little understanding, there should be some document you give to me, and I'll go and do a search. But if we are doing it afresh, then how do we go and do a search to confirm that this land belongs to the families or the farmers who are selling it? My second question, with this scenario where a couple bought a land but could not get any documentation, maybe they were going through the process of doing the documents for them, and then one spouse dies. When the document is coming out, should it be in both names since the other person is deceased? If the spouse that is alive does a land in his name, he or her name alone, would he or she have gone against the law? And then if the person also died intestate, as at the time the person was dying, there was no document to prove that, because you don't have the document. So how do we even add it to document properties to be shared? How will we treat that land finally?
So you help me in recalling the questions from time to time. So the first one was the inquiry as to whether you can get freehold. As we have said, I guess it's a family land, right? Or stool land.
I'm not too sure, because I'm told they are for different people represented by the chief. So what I don't know is whether they are all from one family, but these are farmlands they've planted.
Okay, that you're already working.
And so Eastern region lands, I don't know whether they are stool lands. I can be sure for Ashanti region because all those lands there are stool lands. Greater Accra, I'm sure most of them are family lands. For Eastern region, I don't know.
Likely to be a stool land, but even if it's family, that is where this law, the Constitution actually forbids creation of freehold in stool lands. That's the Constitution. And this law has added family land. So you can't get freehold in family land. So it means that your negotiation should reflect a leasehold. It's only lease that you can get. Okay, it means that you should have a specified duration that they are giving it to you. Okay, normally if it's for residential development, then it's for 99 years. But if it's for commercial, they always reduce even the number of years that you can get. Then you cannot get it. Okay.
Since it's a new land, can we propose for more than 99 years for a commercial use?
Commercial, yes. This one, what the law requires is that it should be for a certain duration. So if it's even 100 or whatever, that is by agreement.
Okay.
But you can't have it perpetually. You can't have it forever, because it should get to a time that it will come, you will lose it for somebody else, and it will be available for somebody else to get it. That is what the law is trying to prevent, that one family or few families will have the land exclusively, and then others will not have access to land. Okay. So the second one is about the you are now going to do the documentation, everything. So that is the difficulty we have. Most of our lands are not registered. So when you are doing search, you won't find anything. And that is why on the ground investigation is very, very important. Talk to as many people as you can find. And then also disposition of stool and family lands must be done in conjunction with the Regional Stool Lands Commission. So it will be better you go there and talk to them and see the nature of the ownership of that land, so that you are sure whether you are dealing with stool or family. Remember, when we say it's stool, it doesn't mean that a family or some other people cannot have it. But it means that the stool may have their Lodier interest in the land, and then the family may have the customary freehold or the refractory interest in the land. And then the last one about marriage, and then
you bought a land
before it's developed One,
So even
before it's registered.
before it's registered, you get
One
you get
dies.
the indenture, one dies,
Good.
and the indenture comes after.
Okay. Good.
You are now preparing. Let's say you are now preparing the indenture.
Okay.
Do you prepare it in the living and the deceased name, or
Good.
you prepare it in the living?
Yes.
And where the deceased died intestate without a will. As at the time, let's say we are accounting for properties, there was no documentation covering that land. So how do we admit it into what is to be shared? And then, so if the other person also registers it in his own name, they have gone against the law or something.
Good. Good. That is a very, very good question. So sometimes you find that they even started the registration with their joint names, and then one is gone. So in whatever state that you find it, the question still goes with who owns the land or who can own the land when one party has died. As we discussed, you deal with your property when you are dead by a will, or if you don't make a will, remember you can also make some unsale, the oral testamentary disposition. If you don't do any of that, then the intestate succession law will apply. And in each case, if there's a will, you go for probate. You actually go and prove to the court that there's a will, and the court will give you an order, which is the probate. And so those are the documents that if you go to court or there's a bank account or whatever it is, that is what they will require. So the executor of the will, the one that you think will stand in when you are gone and then distribute your property, that person is the one who will go to court and get the probate, which is like a court order that will give you right to deal with the property. So when you do that, then you can take steps to go and change it. Let's say you do that and the sharing goes to you. Let's say it was given to the surviving spouse. Then you use that, you apply to the Lands Commission to reflect the changes. If no will was executed, then there's a case of intestacy. So that one is the PNDC law 111 that will apply. Even that, you go for letter of administration, which is also you go to court to demonstrate that the person has died and left so and so property, and you pay the taxes and all that goes with it. Then when you are done, that will also be given to you. And as we have said, you are going to distribute the property in accordance with law. So if it's a case of intestacy, then the PNDC law 111 will apply. And that is where we say that the surviving spouse and children will have property if it's one. If there are more, they will even take one out and all chattels before the remainder is shared, even with they also partaking in the share. Okay, so you have to go through that judicial process before you can make the amendments. You can't just, when you go to Lands Commission, they will even mind you. But that's the only authority that will.
The document is now being prepared. Let's say
The process.
2 years after the other spouse has passed. So the surviving spouse has the chance to put his or her name on it alone. So my contention is that should the surviving spouse do that, will he be the rightful owner of the property, or he or she supposed to declare it because the other partner died intestate to be considered as something to be shared?
Oh, okay.
I don't know if you get my question.
So here, you've moved away from the registration or whose name will be on. So now, whether that property should be part of, let's say if it's he died intestate, whether that property should be put in the pool to be shared. Yes, of course. The fact that
Get that land, even though payment had been made before the other spouse died.
yes,
So let's say after 3 years, you have chased that thing, now you've gotten the documentation. You cannot put the deceased spouse name on it when the documentation is not being prepared for you. So if it goes in your name alone, how do you treat it? Do you have to now come and, after you've shared everything, bring it back and say, okay, now I have title over the land, so come and let's share? Or
no,
the
the
spouse
title is only to perfect your right. You have equitable right in the property when you go through the process. It's just the legal title, the one that by law you can obtain, like the land title certificate and others. Without them, you still can claim ownership to the land. So, but the point is, as soon as one spouse dies, you could even be having the property with another person, not even the spouse. But as soon as that person dies, you can only deal with his part of the property only by a court validation order, just by the LA or the or the probate. So you cannot rely on the fact that, well, I have now done the title registration, so it becomes mine. No. In fact, everything should stop. Everything should stop, and then you go through the process before. Later, we can have a talk for more details. Thank you.
Lawyer, thank you very much. It's been very educative. I was meaning to ask you a question on the spouse issue. Because I heard a year ago that if you're now going to register land, it's compulsory to register it in your name and that of your spouse. But you said that if you're going to register, you'll register in both of your names, except you can prove that you acquired the land independently. So how would you do that proof? I mean, if once you are married, the understanding is that, if it was before marriage, that is different. So how would you prove that you acquired that land independently? Looking at the fact how you acquire land here, sometimes you just go and withdraw your money and then you pay to the person. So how would you prove that that land was acquired independently? So that, and then secondly, the gift issue. So how do you also prove that the land was gifted to you, so that you avoid the issue of having the land in the pool, or the understanding that once you acquired it during marriage? So how do you prove that the land is a gift?
Good.
Aside the fact that it came from your father. So let's say someone, because I see a lacuna there, that's what the lawyers say, right? A lacuna there where if someone sold the land to me, and then I could be able to talk with the person could come and say the land was probably gifted to me. Maybe I had paid money for it at that time, and then I could now come and say that this was gifted to me, so it should be part of the properties considered as acquired by me and then my wife.
Wonderful question. So the first one, actually the law gives you the opening that you indicate it in the conveyance, that you are acquiring it for yourself. But even there, the same lacuna can be raised, because if I put it there, would that be conclusive that I acquired it independently? If between myself and my wife, we have not been acquiring independent property, for example. So it's all about evidence, and I'm sure that the land title registration officers will have to look for more evidence to establish. Maybe call the other party and get more information from other spouse, whether that is how they behave. Because you just asking the one you are getting the land from to put your name that you are acquiring it alone might not be conclusive. The Constitution allows everybody to acquire property either alone or in association with others. So it even applies when you are married. That's why the Supreme Court, they move from the fact that, from the rule that once you are married and you acquire property is joint. But I illustrated the case where, they've been treating their properties, even acquired during the marriage, as independent properties. So you have to do more to come to that determination. And a very good question on the gift. People are very strategic. They go into marriages with a plan that they will divorce at some time. So they manage their affairs in such a way that they buy properties in their family members' names. And later, they can even be given to them as gift. So as you are saying, your fears are very practical. You have a lot of cases. There's a case that came over. The man has acquired, they are a young couple, about 5 years. Within the 5 years, they were doing some fraud, issues and all that. Got the money. The man acquired a lot of properties and used the family members' names on them. So now, when the divorce happened, he's saying that none of the land is for him. And I said that we could push this matter because it's not normal that a spouse or you get into marriage and you don't acquire any property for yourself, but you begin acquiring for your. The court will have to make some interrogation. And that's where, if you get a good counsel, you also bring certain elements out that we don't even have a place. Is it normal that you could acquire 5 properties for your, but it's a good case. That is why whatever you present will not be conclusive. There will be other evidence or other investigation to establish. But these are some of the gaps that in the implementation of the law, surely they will come up. And I'm sure that your case will be one of the practical cases that will challenge the law. Thank you.
Please, because of our time, we'll take Elder Ohin. So please, if you can make it just one question.
Honorable, I thank you very much tonight for this very good education. I've acquired 2 lands. I acquired 2 lands. That was in 1989. And they sold it to me at 800. The 2 lands, 800. As at that time, there was no document on the land, no indenture. But when at 2010, they called me and told me that the elders of the family have decided that the land is sold to me. As at that time, I have not developed the land. So they said because I'm a family member, I should increase the amount. Yes. So I told them that how much would they charge me for the 2? They said, give us 1,000. So the 2 will be 2,000. I have paid them this amount. Then I need a surveyor to go and then do the survey. The surveyor came to me and said that the land is sold to me. The amount is not 1,000, but 1 plot is 4,000. That is 4,000. I said, oh, if you are giving me stress like that, I'm a family member. Why should you do that? They said that you are lucky. People are taking it 150. That's 15,000. And I told them that, okay, if that be the case, I'll rest my case and pay them. So the surveyor did the survey, and then he gave me he asked for my ID card. And I sent my ID card to the survey department. Now he has finished everything. When I went to lands, like you were saying, only my name was on it. But they challenged me like, this time, the law has changed. So if you are, they asked me whether I acquired it myself. And I said, oh, yes. I said, where is your wife? You wear a ring. Your wife name should be in the document. I came to tell my wife. Now my wife too is claiming certificate. The land certificate because there are 2 plots. And so he said that we are going to share it. I'm now in the dilemma. So can you help me? And secondly, the book you are holding, can I acquire one from the Assembly Press?
The Land Act?
Yes.
Yes, it's available.
From the Assembly Press?
Yes, yes.
Thank you very much.
Yes, please clarify your question, the dilemma that you are in.
Before, I wanted to add, how is the, from what you said, the question I want to ask from what he said is, how important is registering your interest in land? As in, if you are familiar with the Bank of Africa versus Gracefield, that case, like how important is registering your interest? Because he's saying he first bought in 1989 or something, and now in 2010 or something, that is, you could have lost it in that period. So how important is registering your interest in land?
Good.
After purchase?
Good. Maybe I will start with that and seek the clarification. So yes, very, very important to register your land. And if you you go through the entire process and you get the land title certificate, we are saying that it gives you indefeasible title. It gives you title that is almost conclusive that you are the owner. And then remember that it's a notice to the whole world, so that if anybody goes to that land and goes to do a search, you will find your name. If that person does not go and still acquire it, the person gets nothing, because there's a public notice that you are the owner. And so for some transactions, the banks that you cited, you need, without those documents, they won't give you. You can have the best of mansion on the land, but without it, they cannot give you any facility. So it is really important that you register. But I alluded to the difficulties that you go through, and if you need the land and the way we struggle with land these days, it's better to at least attempt some development while you are pursuing that. But you even find that in most cases, the land itself, the place is not even demarcated, so they cannot even register it. Just have to settle there for some time, and then you push for that. But it's very, very important. Yeah, so please, if you could clarify the difficulty you have. Yes.
The land title is delaying the certificate. And I know that what I'm going through is between me. But my wife is also challenging that the certificate has delayed too much. For that reason, maybe I might have
Told it or oh, okay.
That is the point.
So one day, please go with her to the Lands Commission for her to see it for herself. Going to the Lands Commission. Oh yes, but they set some targets, but our public institutions, they never meet those targets. But sometimes there are genuine and special cases, because your place has not even been approved. There must be a development plan for the area which is approved by the Lands Commission before. So that alone could hold your process for a very long time. So that may account to your peculiar case. But talking about the right to re-entry, you acquire the land. Sometimes the acquisition is by a contract. And so they tell you that you are to start developing within, let's say, 1 year and complete within a certain, maybe 2 or 3 years. So if you don't do that, then they will have a right to re-enter, take the land back. If you don't do that, people will just buy the land, withhold it, and then when there's appreciation in value, they sell. If you do that, you don't get continuous development. So extending services to the place becomes difficult and all that. That is why they always encourage that. You give it to only serious people who can develop, so that you don't have, patches of development all across the place. It makes, extending facilities, they're very, very difficult. So they have that right, but they hardly exercise that. If not, because you may buy the land, you are ready to, something can come in and you are not able to do it. But if it's for a very, very long time, like your case, then of course, you have that difficulty. But anytime you go into agreement of that sort, once you pay the money, let them sign something. It can be any document. Let them sign that we are taking this money from you as consideration or full consideration for the land or whatever, or as additional payment. There should be something on paper. If not, these are narratives. So if it goes to court, how are you going to? They will counter and say that what you are saying is not true.
Thank you. I wanted to find out under the New Land Act, the provision that has been made for leasehold that have expired. Remember that sometimes you get your documents when, if it is say 50 years, when about 20 years has already passed. So what amicable or friendly way could you settle the matter with the landlord in terms of when the leasehold expires? Yes, if he comes and then he's taking over the land, could you re-enter into a negotiation, or he could ask you to vacate the land? Yeah, what is made available?
Thank you very much. Land acquisition is founded on contract. So you see that for most leasehold agreements, you will have the right to renewal. So you make sure that you have a renewal clause there, so that the person will be bound to have a discussion with you on the way forward. But talking about the delay in getting the papers, I'm unsure that will prevent you from doing something on the land. Okay, you can actually be on the land while you go through the process. So if it is the case that you can only start enjoying the land or using the land when you get the papers, then it should reflect in the lease agreement that it will commence. That's why sometimes I say that the duration can be stated, sometimes it can be ascertained. So it can be conditional, that the lease will commence at the time of acquisition of the land title certificate. Then it will start from there. So it's a matter of agreement. So if you have such a case, then you make sure that that is reflected. And so if he wants to do otherwise, then you go to court and enforce what is there. But you can always, even if there's no renewal clause, that you can always negotiate. And in most cases, you might have developed the land. So he will not charge you as he will charge a fresh user.
So you made mention of the fact that if a man acquires property during marriage, it is assumed that the woman may not have had any financial input in acquiring the property, but it's assumed that the woman gave the man peace of mind, probably provided some domestic services, and took care of the kids. So the woman may have a right over the property. But I'm very certain that it's not all women that are giving their men peace of mind. Some men are really going through a lot at the hands of their wives. Probably even these domestic services are being provided for by house help. Nannies are taking care of their children, which is even being paid for by the man. So how does a woman like that have rights over this property?
Very
is there
good.
a way around it?
Thank you very much. So definitely, as I indicated earlier, it's not every case. That is why I have said that the Constitution itself recognizes that possibility. So it says that property acquired jointly during marriage will be shared equitably, not equally. Okay, so definitely through the divorce proceedings, some of these issues will come up as how long the woman has been doing that. Okay, whether that period has been significant and could affect acquisition of property, then even though it will be joint, but the sharing will take account of your greater effort. But the whole point is that, when we are talking about the woman's duty in the house, it's not childbirth alone. I was just talking about it with a friend, that childbirth alone, which is exclusively held by the woman, is more than anything. That is a carriage of death. So if a woman goes through that, even to give you children alone, you see, it's not just the peace of mind that the woman is not fighting you. That is not that. Then every home, I'm sure that the best of homes will still have some of such difficulties from time to time. But the whole point is that the woman provides so many services to support you. Sometimes when my kids are home, I'm running to go and hide somewhere because the trouble of reporting cases to you alone cannot let you do anything. You are writing, they want to sit on the seat you are writing and thinking. You see? So actually they do a lot of work. But as I said, through the proceedings resulting in the dissolution, all these difficulties will come up. I've cited the case of the footballer, Odati. Yes, the wife is fighting for the East Legon land and, to no avail. It's all because of some of these things. Because you have 3 or so children with different men when you were in marriage. So such a woman, would you say that the court should distribute the property 50-50? No way. So these matters, every issue connected with the matter will be considered by the court to give justice where it's due.
Counsel, thank you. This should be the last one. It's said that possession is a valid title against the whole world until a superior evidence or title is adduced to support it. I want you to help us in the era of adverse possession, because it's one way that we seated here may lose an interest in land, building, or what. So please, in just 1 minute, help us a bit of adverse possession so that we get guided.
Important question. Adverse possession is where you have property, but you have sat and watched another person exercising ownership rights, or more or less challenging your ownership. For example, you have a piece of land, you go, you see somebody building on it. Building on land is your right as the owner. So if somebody is doing it, then that action is rival to your interest. And so the point is that if you see it, it should be visible. It should be open. The person should see you going onto his land and doing something that only the owner can do. So if you see those things and watch on for 12 years, then the law is saying that you lose, it will be statute barred. There's a law on statute of limitations. So when it comes to land disputes, if you watch somebody dealing with your property in such a way that only the owner can do it, and you watch the person do it. You don't say anything. Sometimes you are even called to a party on the land, and you go. Those will be the elements the court will use to demonstrate that you saw the person using the land and you didn't say anything. Okay, so because of that, then the court will say that you've lost your right to sue for the land. Interestingly, the earlier cases, they were even confused as to then what title is the adverse possessor holding. Can he give to another person? And that was a difficulty that he cannot even give you title. But the whole point is that you can't sue to claim it. Then when there's a recent case, then there was a confusion that, does it mean that if I put a caretaker on the land, and the caretaker is on the land for some years and I've even traveled, can the caretaker do that? Remember, if you put somebody there, it's with your consent. So the person cannot claim until you see the person doing, let's say, selling part of the land and you are watching on. It's reported to you, you don't do anything. Then for 12 years, when it's almost done or sold to third parties who have acquired it for valuable consideration, then you come in and challenge. But third party rights will be protected, and definitely that is the case where adverse possession will take place. So it should be visible, it should be open, and you should just watch on without doing anything or asserting your rights.
Let's give our speaker a round of applause. Thank you very much for such a wonderful time. At this point, we want to take our offertory, so bear with my voice. Please, let's rise and bring our offertory.
Shall we humbly rise? The church is marching on. The church is marching on. The gates of hell shall not prevail. The church is marching on. The gates of hell shall not prevail. The church is marching on. I will build my church for my own glory. I will build my church for my own glory, and the gates of hell shall not prevail. I say I will build my church. Hallelujah, I will build my church for my own glory. I will build my church for my own glory, and the gates of hell shall not prevail. I say I will build my church. The church is marching on. The church is marching on. The gates of hell shall not prevail. The church is marching on. The gates of hell shall not prevail. The church is marching on.
Man. All right. God bless you for coming. We quickly want to take our roll call, which is now part of our usual meeting. Can we see the host? Gatekeepers. Let's see gatekeepers on their feet. All right. So we are doing a head count. Okay, gatekeepers. Oh, yeah. You are in gatekeepers, eh? Oh, nice one. So then it was your own program. I didn't even know he was there. Oh, that's nice. Okay, how many are we gatekeepers? Someone, Adade, please put it on the page. 5 of them are here. We are doing the membership league, the group league. At the end of the year, we'll see which the group that came. So there are 5 of us. Courageous men. Let's see how many. 2. All right, Congress. Congress, we have 4. Okay, I saw a hand there. 5. Good. Where's the 6th person? Congress, 5. Okay, we have Warriors. Okay, warriors, 0. Men of honor, 0. Men of valor, 1. Okay, let's put our hands together. Please, anyone here without a group? Okay, so because anyone else? Okay, so because gatekeepers hosted, we'll add you to. Some are what? How many of us have formed our groups, please? Let's see by hand which group. So gatekeepers, courageous, conquerors. 3 groups have been formed. Okay, Daddy, we'll take your names. We've shared everyone we've assigned everyone to a group. We will check and confirm. If you don't have a group, then we'll add you on to one of the groups. The group leader will call you and then introduce him or herself. And introduce himself, A gender balance. Amen. Okay, so I think we'll do that on Sunday. I got the feedback that some of the groups, after they made their calls, some had relocated. So we'll know them. Okay. All right. Thank you very much.